Let's take another call, Cynthia. Let's talk to Vanessa from Northern California. Vanessa, did you have a story to tell or a question to ask?
Both, if that's okay.
Go ahead.
I wanted to say how you guys are doing, and thank you for your show, Vincent. It really helps a lot.
Well, I appreciate that, Vanessa. Thank you for listening, and thank you for calling in today. So what's going on?
Well, it's been a year already since my children were taken from their dad, and they're holding them. CPS is holding them due to false allegations, and what I don't get is that the false allegations are keeping my children from me, but did I have a right to get my children before they were taken from me, because they were taken from their dad?
So were you and the dad living together at that time?
No, we've been separated for 2 years. I've been fighting for custody for my children out of court and now in court because he got them taken from by CPS.
Okay, so what you should do you have an attorney that's assigned to you?
No, I've already had 5 public defenders that all quit on me without even a notice to me. They just quit, and I don't even know who my other attorney is.
Well, you need to find out who your attorney is, and you need to do this. You need to have a meeting, with the file. You and that attorney should go over everything. You should develop a legal strategy with that attorney, and then you and the attorney should implement that strategy.
See, I've tried to do that, and they all tell me that I'm guilty of the false allegations, and they just want me to sign over my parental rights, which I don't think it's fair because the allegations are way out. Like, first of all, the allegation is of my son, was 10 years old. He's 15 now, that he was hospitalized for 4 years and was 5150, and they don't even have no evidence of that because I had my son when he was 10, and there's no evidence to back that up.
Well, you have the right. You and your attorney have the right to make a discovery request and ask the county and ask the social worker, hey, what documents are you relying on to say that my son was 5150 during a period of time when I had custody of him? Because it's just not true. So that's what you and your attorney should be asking for.
Okay. Well, actually, I'm going to have to self-represent myself.
No. Don't do that. Please, Vanessa, please don't do that.
I'm trying, but I did file for discovery by myself, and I wrote a declaration to the judge, and I filed that in court. I made some police reports, but I'm not in the position right now to even hire an attorney. And like I said, the public defenders are on CPS's side automatically. And the attorneys that they do assign me, they're for probate. They're not even really for family law, which I'm in juvenile dependency court. So
yeah, it's not a family law case. It's a juvenile dependency case. And you hope that you would get assigned an attorney that, has experience in juvenile dependency cases, knows the law in that area under the Welfare and Institutions Code and also the California Rules of Court.
Yes.
I hear this frustration all the time, though, feeling that the attorney is on CPS's side. And Vince, is there an amount of attorneys that you're allowed to have before they say no more?
No. No. There's no law that says that. It's up to the discretion of the judge. So if I were Vanessa, I'd ask the judge to assign me one more attorney.
Okay. And what's lawyer malpractice? Like, if they quit on me without, I had to go to court by myself. I didn't even know that they quit when I was going to hearings.
Mm-hmm.
So I had to go by myself to court, and the lawyer wasn't even there.
I don't think in California, and I don't know the practice in Fresno County, but I don't think an attorney can just quit without telling you and without giving you the opportunity to get another court-appointed attorney or a private attorney.
I've heard that just recently, though, also, that they quit and don't give notice.
Yeah, in California, that's not proper. I can't imagine it's proper in any state, but, I'm not sure. But in California, that's not the rule. California, you actually have to have the client sign a substitution of attorney and file it, or you have to make a motion to be relieved as the attorney, but, notice is given to the client and the judge makes a decision after finding whether notice is proper or not. So, that's just not showing up. I'm not sure that is proper, but, are you sure you're telling me all the facts, Vanessa?
Yes,
Okay.
I am. I promise I am. I'm not leaving nothing out.
Okay, Vanessa, do me a favor. Give me a call at my office, 888-888-6582. See if I can help you a little bit more. I have to take a break right now. This is The Secret, How to Fight CPS and Win. We'll be right back with Cynthia and more calls and more questions.